If you're dealing with the personal property of a deceased loved one, you're probably feeling pretty overwhelmed, right? Um, Today, what we're doing is we're breaking down exactly what you need to know about handling personal property items in a probate estate in the state of Missouri. Things like furniture, jewelry, and other personal items during probate. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney out of St. Charles, and I've helped hundreds of families across the state of Missouri deal with probate after the loss of a loved one. So first, let's talk about what is personal property. So personal property is basically anything that is not real estate, right? So cars, bank accounts, life insurance, stocks and bonds, the stuff in their house, clothes, jewelry, furniture, all that kind of stuff, okay? And it is the responsibility of the estate representative to protect and gather this stuff up and preserve it and secure it and insure it, make sure that it is not being stolen or destroyed. So, when somebody passes, like making sure the house is secure or apartment is secure so that nobody's breaking in and taking stuff, so that even other family members are not breaking in and deciding for themselves, like who's going to get what. That in general can be handled outside of court, and in many cases it should be handled outside of court. But if there's any kind of dispute over items of personal property, it is important to make sure that they are handled through the probate process. All right. So here's a couple of basic transfer rules to understand. Most items of personal property that you generally will be dealing with, things like bank accounts and cars and a lot of them, they might have a transfer on death on them. They might have a joint owner on them. It causes those assets to transfer automatically outside of probate. But lots of stuff just doesn't have a title on it, like jewelry and furniture and clothing and TVs and appliances and stuff like that. There is no owner on that. There is no transfer on death. You can write transfer on, most people don't realize this, but you can write transfer on deaths for that stuff. Well, most people don't. And as a consequence, it technically belongs to the probate estate. Now in Missouri, actually property falls to the heirs as a matter of law automatically when somebody dies, and it is subject to the control of the personal representative in the probate estate for the purpose of paying creditor claims. So you can actually think of probate as kind of mostly there to protect creditors, but it also does create a system of orderly administration in the transfer of property. Okay, so you want to get that stuff secured, make sure that you have a plan for how you're going to be distributing it. Most of the time that property belongs to the heirs and should be distributed to them. And a lot of times people get real upset. Like somebody goes into a house and decides to take a few items of property. And the reality is it's complicated. Should it go through probate? Yes. Should it be handled through the probate process? Yes. But as a practical matter, those people have an equal right to claim that property as well. And technically, the personal representative only has a right to possess it if they are using it for the purpose of selling it to satisfy a creditor. Now, you can get into situations where you have to file what's called a discovery of assets, where you have to pull property back into the estate, or you can have a dispute with somebody where you can say maybe they're claiming property as theirs when actually it should belong to the estate to be distributed, or maybe they've stolen property from the estate and aren't properly dividing it with the other heirs. That's a problem, right? So even though people have rights to use and possess property, that doesn't mean that they have the right to steal it and not share the proceeds if they sell it with the other heirs, right? So it can be important in certain circumstances, especially if personal property is valuable, like art collections or any kind of collectible that is worth anything of significant value. It can be important to make sure that those are put on an inventory in probate. Those are appraised by an appraiser who actually knows what they're doing in that particular type of property, and then handled appropriately. Sold to an appropriate buyer, the cash distributed according to the will or the intestate heirs, whatever is required under that particular situation. But what I do caution people against is if you have a situation where somebody has, so-called stolen the personal property, you got to be careful not to throw good money after bad. Because personal property disputes are sometimes the most hostile. They can be the biggest waste of time and money. It feels important and it feels valuable. But how valuable is it when you're 10 hours into your attorney's time and dealing with these personal property issues for grandma's ornaments? You know what I mean? It can be a source of huge anxiety for families, but also a huge source of throwing money away on disputes that really, unfortunately, have to be left alone. Sometimes you can contact the police if there was an actual theft involved. But a lot of times the police are just going to tell you, sorry, it's a civil matter. So then you're stuck back in court and filing lawsuits against your siblings and your family to try and pull those pieces of property back in. And the reality is a lot of times those people are going to say, I don't know what happened to it. It's gone. And how are you going to cross-examine that? How are you going to defeat that argument? It can get very difficult. And it's one of the reasons that we try to stay away from disputed probate cases, is because that stuff is just, it's not fun and it's not pretty, and it's not fun to represent people in that context either. So with personal property, you got to be very careful. But in general, it's not a bad idea to list that on the inventory, have it run through probate, and then divide it appropriately according to the will or the intestate distribution, whatever is appropriate under the circumstances. All right. Very rarely are you going to be subject to valuation requirements or imposed appraisals by the judge or by anybody else. Only time that's necessary, in my experience, is if the asset is really valuable and there's some dispute over the value of the property, or if the personal representative is trying to sell it at below market value or something like that. You may end up in a situation where you have to get it appraised. But most of the time, that is not going to be necessary. There are situations where it can also be relevant on estate and gift tax returns. So if you have a very large estate and we need to value it for tax purposes, that may also be relevant. But for the most part, we're just using county values. We're using estimate values. We're using internet values. We're not using formal appraisals unless ordered by the court. So you have to consider those cost-benefit analyses as you're going through these cases. Most situations don't warrant that kind of expenditure, that kind of excessive investigation of asset valuation, things like that. But there are situations where it does make sense. Other things to be aware of in the personal property context: if you have like a car with a lien on it, for example, or other personal property with a lien on it, in Missouri, there's a 4-month creditor moratorium on foreclosure of that property. So your auto loan lender, for example, cannot repo the car for at least 4 months after death, even if the loan is no longer being paid. Now, a lot of times when you're dealing with personal property like cars, that's going to be a big question right out the gate. Is if the car has a loan on it, is the car underwater? Does it actually have any equity? And if there's no estate open, there's nothing wrong with letting that car go back to the lender and letting it be their problem to come pick it up and come deal with it. Now, if there is equity, especially if there's significant equity, it may be worthwhile to make sure that you can try and get in there, get probate open quickly, and get the car sold so that you can pay off the lender and pocket and bring some of the excess cash back into the estate. So if you do have personal property, whether it's disputed or not disputed, it is generally a good idea to have some kind of plan as to how you're going to distribute everything. I encourage people, bring everybody over to the house or the apartment. Have everybody come through, see if anybody wants anything, let people take what they want. If there's a dispute over something, come up with a system for adjudicating that dispute that doesn't involve lawyers, doesn't involve courts. Drawing lots from a hat, flipping a coin, letting people buy it out of the estate. Whatever it is, come up with some way of, some informal way of divvying up the personal property. And if everybody has their hand in the process and has the ability to be involved in what happens to the personal property, even though it's technically the responsibility of the personal representative, it can minimize disputes. It can help people feel like they have ownership and involvement in the process, because oftentimes communication barriers and people feeling like they're being left out of the process is one of the major sources of family division and fighting and stuff like that. So just be reasonable, invite people in, make sure that you're communicating with them, and that's part of the pain of being representative and dealing with the job is your job to be the communicator, be the liaison. Talk to the attorney, talk to your family, keep them happy, make sure that they're aware of what you're doing. Don't act in shady silence, because if you do, they will assume you're being shady, right? So that's kind of my suggestions on communication, dealing with personal property. In some cases, it can make sense to get a storage locker or otherwise bring the personal property out. Like if it's in an apartment, for example, and the apartment owner wants to clean it out, it may be important to get that property out and get it stored somewhere secure. It's a good idea to take lots of pictures of everything when you first get started, so you know what's there, if anything is missing, if anything is damaged or needs to be covered by insurance, anything like that. Make sure you have pictures and an understanding of what's going on there. If you have anything that's valuable of personal property, make sure that that's being covered by the insurance that covers the estate and or is covered by some policy so that if something happens, there is coverage there. So those are the things you need to know about personal property. It can be part of the probate estate if it doesn't have a joint owner or a transfer on death. It can be important to process that appropriately. Try to look for doing informal distributions of personal property wherever possible, unless it's absolutely necessary because people are pushing you on it or fighting you on it or something like that. Look at alternative division systems, rolling dice, drawing lots, whatever, it doesn't matter, to come up with a way of dividing that property out. You may need to get appraisals. If you do, make sure you get a specialist appraisal in that thing or somebody who knows how to value that thing and get that thing sold so that you can actually get top dollar. We had a client who had a collection of rare seashells. There were very few people who have any idea how much that stuff is or can be worth. So we had to find a specialized appraiser to deal with that kind of asset. So be thinking about that if your deceased loved one has anything like that going on in their situation. So again, my name is Dan Schnurbush, probate estate attorney out of St. Charles, St. Louis, Missouri. I hope you enjoyed this video. If you did, hit that like button, subscribe, and check out some of our other videos if you want to learn more about Missouri probate. Until next time, guys.